Srishti, you did your law from where?
So I completed my LLB from KCL Institute of Laws, Jalandhar in the year 2018.
Thereafter, you have studied somewhere else or not?
So I just completed my LLB and since then I have been preparing for judicial service.
You are belonging to which place?
So I belong to Jalandhar, Jalandhar city, Punjab.
Alright. Why you want to join this judiciary when you are at Jalandhar, you can practice there and it will be far away from your Jalandhar to Haryana. So how you will manage? Why, first of all, what is the reason why you are going to join this profession?
So my dream is to become a judge. I joined LLB with the sole dream of becoming a judge. I believe that judiciary in India is one of the most dignified and secure jobs. Also, it is the independence of judiciary which attracts and inspires me to become a judge. A judge is never affected by any kind of interference as compared to bureaucracy. He is free to give the decision which he feels to be the right. So it is the independence of judiciary which inspires me to become a judge.
Now, in case you are selected here in Haryana and you are working in Haryana, and definitely when posts of Punjab are advertised, you will also apply for that. Will you leave the job of Haryana?
So, with due respect, as I just said, my dream is to become a judge. And if my dream is materialized here, I shall be more than happy to serve here.
What do you know about attack of Russia on Ukraine?
Sir, any attack, any war which results to the death of innocent lives, it cannot be justified. Though the Ukraine is bearing the brunt of its own actions, Ukraine tried to bring NATO to the doorstep of Russia, which did not go well with the Russians, and as a result, Russia invaded Ukraine. But still, this act cannot be justified because such act results in the death of innocent lives who are at no fault.
Yes, sir.
When a court may appoint and remove guardian.
Ma'am, the court can appoint a guardian when the person to be sued or person who is suing is a minor or a person of unsound mind. In such situations, court appoints a guardian.
Which provisions of law are there to deal with such?
Sir, it is Order 32, I'm not wrong.
Yes,
Order 32, Code of Civil Procedure.
Yes. Shape.
How will you differentiate between the stage of preparation to commit an offence and an attempt to commit an offence?
Ma'am, there is a difference between preparation and attempt, and there have been many theories upon this point. The basic point of difference is that if the accused, the offender, the prospective offender, he drops the idea of committing the offence at the last moment, it has to be seen that whatever he has done, is it injurious to someone or something, whether it can be counted as an offence. If what he has already done will not cause any danger or threat, it will only amount to preparation. But if he has done an act towards the commission of the offence which cannot be reversed, it would amount to an attempt.
Alright, 16. What is inquest report? How it is prepared? Who is preparing?
Sir, Section 174 of CRPC deals with inquest reports. Whenever a death has occurred because of some suicide or maybe under mysterious circumstances where the cause of death or the offender is not known, then the inquest is conducted for the sole purposes of finding out as to the cause of death, and it is the executive magistrate who conducts inquest.
Whether judicial magistrate can also do that?
So, judicial magistrate can also conduct inquest under the circumstances mentioned under Section 176, that when a death of the woman has been caused within 7 years of her marriage and there is a suspicion that she might have died because of dowry death, or when her family has raised the allegations that such matters should be looked upon.
Alright.
Who are ad hoc judges?
Ad hoc judges are the judges who are not appointed permanently. They are serving temporarily for provided period of time. They do not have the status of permanent judge.
Is
Yeah.
there any civil judge also who is ad hoc?
Sir, there are provisions. Sorry, sir.
But special courts are.
Special courts, yes.
Special courts for 1 year.
Yes,
They can apply for 2 years also.
yes.
Special judicial magistrates and special civil judges also. Addition.
What is the procedure for recording confession?
A confession is recorded by the provisions of Code of Criminal Procedure. Confession can be recorded at two stages, either at the time of investigation or during trial. When the confession has to be recorded at the time of trial, the accused is free to make a confession at any time. He can give the confession during the statements under section 313, or he can himself produce himself as a witness under section 315. But where the confession has to be recorded during the process of trial, the provision has been given under section 164. The police will bring the accused person to the court, and the magistrate shall first of all satisfy himself that the accused person is willing to give the confession voluntarily without any kind of pressure. And after making him understand that what will be the repercussions of his confession, he can record the confessional statement, and at the end of it, he will record the statement that everything has been made understand to the accused person, and the confession has been read over and admitted to be correct.
Feel at home and be slow. Don't be in a hurry. So, what is the revision in the criminal side?
So revision, the section 395 to 405 of the Criminal Procedure Code deal with revisional power. In criminal procedure, the revisional power has been given to the Court of Session and also to the High Court. Whenever these courts are of the opinion that any proceeding by a lower magistrate has been done wrongly, or they have failed to exercise their jurisdiction, or they have passed any order which is not justified on the matter, they can either himself call the record of the case, or even the aggrieved party can apply for the revision.
Right. Suppose some order is appealable. Can revision be filed?
No, sir, revision can be filed only in those cases from which no appeal lies.
Can High Court revise that?
Yes, the High Court is fully empowered to suo motu call for the case for revision, but as far as applying for revision is concerned, the aggrieved party can apply only if the case is non-appealable.
Whether judicial magistrate can review his own order?
No, sir. The power of review is with civil judges, but as far as judicial magistrates are concerned, they don't have any power of review. However, honorable high courts have the power of judicial review. They can review their own decisions.
Judicial review. Now, we are talking about review, not
No,
judicial
sir.
review.
Judicial magistrates have no power to review.
Whether Supreme Court can review its own order?
Yes, the Supreme Court can review as per Article 13. They have the power of judicial review.
I am talking about only review, not judicial.
Yes, sir, they can review, but I'm not able to recollect the article right now.
Is it 137 or 138?
So 138.
It is 137. Go through that again. Alright, Arun.
What are the powers of civil courts?
So, ma'am, civil courts have the power to deal with all the suits which are of civil nature, and they have the power to pass such order upon the cases which the matter and justice requires. Also, all the civil courts in India have been granted inherent power as per section 151 of Code of Civil Procedure. So, when the merits of the case require to secure the ends of justice, civil courts are granted inherent power.
Yes, Srishti, suppose some person wants to prove mortgage deed in the court. How he will prove that mortgage deed? That which type of witness is required to prove mortgage deed?
So, Section 91 of Indian Evidence Act says that whenever the terms of a contract are written in the form of a document, it is the document itself which has to be proved. Apart from that, the attesting witnesses can be brought in the court.
Can you cite some provisions?
So I'm yet to read TP. I'm not very sure.
Is it 67 or 68?
Sir, I cannot recollect because I'm yet to read.
It is 68. It is 68. One of the attesting witness can prove that. So what is the position of will?
So will has to be proved by attesting witnesses even if it is registered or not.
Is it necessary to get it registered?
It is not compulsorily registerable, but even if it has been got registered, it has to be proved by bringing in or calling at least one attesting witness.
Suppose a person has died and there are two wills, one is registered, another is unregistered. Unregistered will was written afterward.
So, sir, in that case, it is the will which was written at later period of time that shall prevail. Because no law requires that the will should be registered compulsorily.
What is the constitutional validity of conjugal restitution of conjugal rights?
Ma'am, restitution of conjugal rights in the case of Saroj Rani vs. Sudarshan Chadda was held to be constitutional, that the purpose of the section is to preserve the institution of marriage. However, a petition has been filed in Honorable Supreme Court challenging the constitutional validity of the relief of restitution of conjugal rights on the ground that such right attacks the right of privacy and right of integrity guaranteed by Article 21. However, the matter is still sub judice, but up till now, the present position is that it is very much constitutional.
Yes, since you are discussing with regard to marriage, so if the communication is made during marriage by husband to wife, can it be disclosed? Can the wife disclose that?
So, Section 122 of Indian Evidence Act clearly lays down that whenever a communication has been made by husband to the wife or vice versa during the period of marriage, no court can permit or compel any person to disclose that marital communication. Such communication enjoys the privilege of being privileged communication.
Alright. Srishti, do you know what is living will? What is living?
Sir, the concept of living will was discussed by Honorable Supreme Court recently in Common Cause Registered Society case. And living will is a will which is written by a person, maybe who is upon deathbed, and he is suffering from some serious illness, and he can write a will that if this condition deteriorates, then the medical facilities can be withdrawn. And such will must be attested by at least 2 witnesses, and it should be certified by the doctor that the person cannot recover, and it should also be before the magistrate. So the living will is a will which is written by a person during his life, and it also takes effect during the life of the person, as compared to an ordinary will which takes effect after the person has died.
Such will is required to be attested by whom?
So it should be attested by at least 2 witnesses.
Attested by which public authority?
So judicial magistrate,
It is judicial.
and doctor should also certify.
Doctor will Doctor may or may not, because he is hale and hearty. We have to honor his wish. That what that person wants. He is reducing whatever his wishes into that way.
What is preliminary and final decree?
Ma'am, a decree can be preliminary decree or a final decree. A preliminary decree is one which declares the rights of the parties, but it does not completely disposes of the matter. It means that something still needs to be done for the final and complete disposal of the matter before the court. But the final decree is the one which not only conclusively determines the rights of the parties, but also puts an end to the matter before the court. So nothing is remained to be done after that.
Yes, Srishti. With regard to punishment, we say that whether the imprisonment is concurrently or consecutively. Can you distinguish concurrently or consecutively?
So, as a general rule, whenever an offender, accused person is convicted for 2 or more offences at the same trial, his conviction and his sentence for these offences will go consecutively. It means one after the other. When conviction for one offence is expired, it has been completed, then the other sentence will start to begin. But consecutively means that magistrate, while convicting him, can specifically provide that his sentence will run concurrently. That all his sentences for all the offences will go on at the same time simultaneously.
Alright, Shreya.
Under which circumstances the right of private defence of body extends to the causing of death?
Ma'am, Section 100 of Indian Penal Code provides for the circumstances where the right of private defence can exceed to causing death. Such circumstances are when the person who is exercising the right of private defence is under the apprehension that death will be caused to him, or some serious grievous injury will be caused to him, or he or she shall be subjected to some offence for gratification of unnatural lust, or he may be subjected to acid attack or any other injury which reasonably causes apprehension of death.
Yes, Srishti, in Haryana, which are the civil courts? How many kinds of civil courts are there in Haryana?
Sir, in Haryana we have Civil Judge Junior Division, Civil Judge Senior Division, Additional District Judge and District Judge.
Additional civil judge senior division. That's all division. Yes, one question.
Under which circumstances directive principles of state policy prevail over fundamental rights?
Ma'am, whenever directive principles of state policy are in contravention of the fundamental rights as contained under Part 3 of the Constitution, in such cases directive principles will not prevail. I'm sorry, this is-
Alright. Now, what are the powers of the civil judge to try the civil suits in Haryana?
So power as in pecuniary power.
Yes, it will be power with regard to civil suit. Whether a civil judge can try all the civil suits.
So during the first 5 years of service, civil judge can try the suits where the value of the subject matter of the suit is not exceeding 10 lakh rupees.
The same rule in
Yes.
Punjab. Exactly the same. It is also in Punjab. It is also in Haryana. Yes, Srishti.
What is the subject matter of the contract under Sale of Goods Act?
Subject matter of the contract is it is the goods, like
It's the
goods,
movable goods.
movable
You can say
property.
that particular. Alright. Yes. Say.
Can sections 34 and 149 of IPC invoked together? If yes, under which circumstances?
Ma'am, section 34 and 149 are overlapping sections. Section 134 deals with common intention and section 149 deals with common object. So when both the sections are overlapping and the number of accused persons are more than 5, then certainly both the sections can be invoked together.
Srishti, suppose some accused has been acquitted. How appeal can be filed by the state or by the complainant against such order of acquittal?
Sir, section 382 of CRPC deals with appeals against the order of acquittal, and section 377 also deals with the power of the state government to prefer an appeal. Whenever the state government is of the opinion that I got confused. State government can file and prefer an appeal only for enhancement of sentence. Sir, in such cases, the complainant can file.
State government can also file appeal against acquittal or not? It can also file. Whether a complainant can file appeal against the acquittal.
Because suppose state says that it is not a fit case for filing an appeal, but in fact the aggrieved person is a complainant. If complainant wants to file an appeal, can he file an appeal?
Sir, proviso to section 372 makes it very clear.
Exactly, that is the point.
There are 3 circumstances where he can file.
Alright. Where he will file that before the High Court or before the Session Court?
Sir, he will present the appeal to the court to which the appeal ordinarily lies against the order passed by the court. It may be
Yes.
court of session or it may be High Court.
Exactly. Harman?
What is specific relief? Whether specific relief can be granted for enforcement of criminal law?
Ma'am, specific relief is a relief which provides for the particular relief that which the claimant is claiming. In section 4 of specific relief clearly provides that specific relief can be granted for enforcing civil rights, but as far as criminal rights are concerned, it cannot be granted for the mere purpose of enforcing penal rights. But when the penal rights are connected with the civil rights or there is some matter of civil nature involved in the matter, then certainly court can grant specific relief for enforcement of penal rights.
Yes, Srishti, suppose there is a suit for foreclosure and you being a judge want to pass a decree. How that decree is to be passed in a suit for foreclosure? Do you know any provisions of that?
Sir, I am yet to read all the provisions of TP and Order 34.
No, it is order 30.
Sir, I am yet to read that. I was planning to read it along with TP.
Definitely good. You may not go through all the provisions of TP, but do remember this order 34 because it is a part of the CPC. They can ask any question out of this. Yes, Lalita, one.
What is the difference between divorce and judicial separation?
Ma'am, in divorce, when the decree for divorce is granted, there is termination of marriage. No marriage, no relationship between the man and woman exists after the decree of divorce. But in case of judicial separation, the matrimonial rights are only suspended during the period of judicial separation. The parties are still husband and wife, but only marital relations are suspended for a period.
Yes, Srishti, recently, a Prime Minister of India visited Haryana. Can you narrate for what purpose he has visited, what he has done in Haryana and in Punjab also?
So recently, the Honorable Prime Minister of India had visited Mohali and Delhi for opening of the cancer hospitals, because they are planning to open cancer hospitals in almost all the districts so that there can be comprehensive treatment for the.
What is the name of that hospital?
So in Mohali, it is Homi Baba Cancer Care Hospital.
Yes.
I'm not sure about the.
No, this is correct one.
Delhi.
And in Haryana, what was done by him?
So he was there to inaugurate a hospital only, but I'm not.
In which district?
Gurgaon.
No, when was that? Because you are going to appear in Haryana. It was Faridabad, and he inaugurated some hospital there, Amrita Hospital. I remember these things because it's very essential. Recently, whatever is being there is related to Haryana. Do have tomorrow. Yes, one question.
What are the circumstances when a police officer can arrest a person without the order of JM and without a warrant?
Ma'am, Section 40 of the Criminal Procedure Code deals with the power of the officer to arrest without warrant when the offence with which the accused person has been charged is punishable with imprisonment up to 7 years or less than 7 years. Then, as a general rule, the police officer will not directly arrest him. The police can give him notice, and only if the case falls under the conditions specified under that section, the police officer can arrest him. However, if the offence's question is punishable with 7 years or more than 7 years of punishment, then the investigating officer can arrest him.
Alright. Srishti, how collegium of Supreme Court came into existence? Whether there is a provision in the Constitution?
Sir, Constitution does not provide for any provision as to creation of collegium. The collegium which we have in the present time is a result of a long effort, and there have been many authorities, there have been many changes in the law, and finally in 2015 in Supreme Court Advocates on Record Association versus Union of India, the present collegium was brought into existence with 5 members in the collegium, the Chief Justice of India and 4 senior most judges of the Supreme Court, and this is the present collegium system which is working.
No. Which was the first case?
The first case was SP Gupta versus Union of India, where collegium was created, where it was held that there will be it will be the decision of the president regarding the appointment of judges. But the decision was overruled by Honorable Supreme Court in Supreme Court Advocates on Record versus Union of India case of 1994.
Alright. Srishti, what is the difference between writ of prohibition and writ of search?
So the purposes of both the writ is same. Both are issued to judicial authorities, and but the difference between both the writ is that writ of prohibition is issued in order to prevent the judicial authorities from proceeding or from passing a particular order. But when the order has been passed, then the writ of certiorari can be issued to set aside that order which has been passed by judicial authorities.
Luther.
Under which circumstances adultery is still relevant?
Ma'am, adultery as an offence has been struck down by Honorable Supreme Court. However, adultery is still a ground for divorce.
Srishti, there is on section 167, subsection 2. It is dealing with what in the CRPC?
So it deals with default pay, that a person has to be during the pendency of investigation for how much maximum period the person can be detained in prison. And if the police report is not presented between the 60 days or 90 days as the case may be, then an indefeasible right accrues to the accused person to be released on bail, but
Right.
only before the presentation of police report.
90 days are to be calculated in which cases?
90 days are to be calculated in cases where the accused is charged of an offence punishable with death, imprisonment for life, or imprisonment where the term of imprisonment is not less than 10 years.
There is one section, there is one accused against whom charges are of robbery. under section 392. Now under section 392, he has completed 70 days. Now punishment is 14 years there under 392. You are working as judicial magistrate. He presented bail application before you when he has completed 70 days. Will you release him or not?
Sir, if the police report has not been presented within the set period of 70 days, then certainly an indivisible right to be released on bail has been accrued to him. Because though section 392 provides the punishment of 14 years, but the punishment may extend to 14 years. Had the punishment been not less than 10 years, then the period would have been 90 days.
Alright, yes. Next.
What is unlawful assembly? Can any assembly of 5 or more persons whose object is not one as mentioned in section 141 of IPC be termed to be an unlawful assembly?
Ma'am, as per the provisions contained under 141 of Indian Penal Code, an assembly of 5 or more persons can be held to be an unlawful assembly only if the object of the assembly is one of the objects as enumerated under section 141. If the assembly is not having any of the objects as provided under that section, it cannot be termed to be an unlawful assembly.
Yes, Srishti, can evidence in the shape of examination in chief be produced before the court through an affidavit?
Sir, Order 18, Rule 4 provides that in case of examination.
No, in criminal courts. Because in criminal courts, Order 18 is not enabling you.
No, sir, in criminal courts, the examination in chief has to be in person.
In all the cases.
So, however,
I
there
think-
are section 295 and 296
Exactly.
of Criminal Procedure Code.
Strike that section.
Yes.
Very
They
serious.
deal with providing evidence to affidavits.
Is there any other case where the evidence must be on affidavit only in criminal side, but not in IPC offences not relating to IPC? Are you having knowledge? Under negotiable of the Instrument Act, all the cases, in all the cases, affidavit is to be produced. Yes, Louis.
What is a probate? So, I'm not very sure, but if you allow me, I will.
Yes.
Probate is a document relating to will of a person. It contains the details about the will of a person. It is certified by the court.
Only answer is only certified will is it.
Certified will.
It is to be certified by the public authority after taking evidence. Yes, Srishti, you might have read suspension of sentence. Can you refer the provisions?
So,
And what
section
is suspension?
389 of Criminal Procedure Code provides for suspension of sentence whenever accused person has been convicted and he has been convicted of an offence which is punishable with imprisonment of up to 3 years or more, and he has been sentenced to sentence, then he can apply for suspension of sentence either to the court which has convicted him or to the High Court, the court where appeal can be filed. The purpose of suspension of sentence is to allow him so that he can reach the appellate court and file for appeal against his conviction.
Yes. Suppose session judge has given 4 year imprisonment. Can he also suspend that because he is a session judge?
So session.
He is trying the case. Session judge is trying the case. He is a trial. He is a appellate court also, but he is a trial court. Being trial court, can he suspend the
So
sentence?
trial court cannot suspend the sentence in such a case. In such case, he will have to reach the appellate court.
Suppose you being a judicial magistrate has suspended the sentence and you have also imposed a fine. Can fine also be suspended with that because he wants to file an appeal?
So section 389 only deals with suspension of sentence.
So which section is dealing with the suspension of fine?
So I'm not very sure.
Absolutely wrong. It cannot be suspended.
Yes. Only sentence can be suspended.
Sentence can be suspended, fine cannot be suspended. Yes, Srishti.
What are inquiry offences?
What are?
Inquiry.
Inquiry offences are the incomplete offences, which offences are not complete. For example, an attempt to commit an offence is an inchoate offence because though an act has been done towards the commission of offence, but the offence is not yet complete.
Alright, Harna.
On what grounds delay can be condoned in civil cases?
Section 5 of limitation.
Yes. Sir, I know the provision, I just did not come in my mind, yes.
Nothing to worry. Can you explain?
So Section 5 of Limitation Act provides for condonation of delay in certain cases, but the delay can be condoned only in cases of appeals and applications other than execution applications. That too when the appellant or the applicant can satisfy the court that there was some sufficient cause which prevented him from appearing before the court. And even if such sufficient cause has been given, it will be the discretion of the court to condone the delay or not.
In civil suit also?
No, sir. In civil suits, there can be no condonation of delay. However, if the person was under some disability as provided under Section 6 of Limitation Act, in that case, he can be allowed to file the suit after the termination of disability.
Can delay be condoned by criminal courts, judicial courts?
Sir, though the criminal code has its own limitation, rules relating to limitation, but if the court is satisfied that there was reasonable cause for not making the complaint, then on being satisfied of the grounds, then the court can allow.
Can you refer the provisions?
So Section 472.
3,
472.
4, 7. In order to make in order to equal activities and everything. Right.
So what is the difference between public servant and servant of government?
It is one and the same thing or some difference?
So both public servant and servant of the government are the employees of government.
And both have been defined as somewhere or it is only one?
So only public servant has been defined under Section 21 of.
Servant of government has not been. It has also been defined. It has also been defined. The difference, what is the difference? Government servant here appointed by the government, whereas public servant he can be appointed by the court. Local commissioner is also public servant. He can be appointed by the court also. See that both the provisions in IPC. Yes, look.
What is a money bill?
What is a money bill? A money bill is introduced. A money bill can be brought before either house of the parliament only upon the recommendation of the president, and it can be produced only in Rajya Sabha first, and it has to be
In the Rajya Sabha?
in Lok Sabha. So I have
Lok
not read.
Sabha.
I am going through constitution.
Only
I'm not
only
Lok Sabha on the recommendation of president, and it has to be presented within the period of 14 days, if I'm not wrong.
No, Rajya Sabha is bound to pass it.
14 days, yes.
If it does not pass, then it is deemed to be.
It is deemed to have been
I think
passed.
we should conclude.
Yes, sir.
Alright. Nicely you have given a reply. We wish that you must come there. Still, we will bring you in the class.